please be seated. Just before we call the next witness, can I say something more about the non-publication orders for patrons? This morning, when I lifted the orders in relation to 3 patrons, Mr. Petkoff, Mr. Tan and Mr. Tan, I want to make it clear that the lifting of that order was in relation to the naming of the person during the evidence given by Mr. Richard Smith and in the documents that were referred to in the documents that were referred to during the examination of Mr. Richard Smith. It would not authorise the publication of his name if, perchance, it came from any other evidence, documentary or oral, given to this Royal Commission. And by way of clarification, I would add that that does not, of course, prevent the publication of the name in connection with other material outside this Royal Commission that is in the public domain. Now, I think we have Ms. van der Klauw. Please come forward. Would you give us your full name for the record, please?
It's Denise Andre van der Klauw.
And do you wish to swear an oath or make an affirmation?
The oath? Okay. I, Denise Andre van der Klauw, swear by Almighty God that the evidence I shall give to this Commission shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Please sit down. Yes.
Please, the Commission. Ms. van der Klauw, you've prepared a witness statement for the purpose of this hearing, have you not?
Yes, I have.
I ask for document CRW 998 002 0537 to be put on the screen. Thank you. Now, do you recognise that from the front page as your statement of 15th of September 2021?
Yes, I do.
I understand you have a change you'd like to make to paragraph 50D,
Yes.
which is on page 0547. And what's the change you'd like to make to that?
The actual availability of funds advance facility is to not just junkets, but also to individual international patrons playing on international programs as well.
Thank you. Do you have any other
No.
changes? Thank you. So if on your copy, on the last page of the statement, which is 0555, can you confirm that that's your signature?
Yes.
And then on page 0556 onwards, over the next 3 pages, is a list of documents referred to in your statement.
Yes.
I understand that the Crown have made an application for non-publication in respect of some of those documents.
All right, well, we can deal with that as
things involved in the usual conditions. Thank you.
Thank you. So, Ms van der Klauw, can you confirm that the contents of your witness statement are true and correct to the best of your knowledge and belief?
Yes, I can.
Commissioner, I'd like to tender that statement.
thank you very much. The witness statement of Denise Andre van der Klauw dated the 15th of September 2021, bearing the identifier number CRW.998.002.0537 will be admitted into evidence as an exhibit. Thank you.
Please, Commissioner.
Mr Futrell.
May it please the Commission. As without a call, my name is Michael Futrell. I'm one of the counsel assisting the Commission. I'm going to ask you some questions. Can I just start with that correction? I didn't quite catch it to paragraph 50D of your statement.
Yep.
Could you just perhaps read out how you think you say it should now read?
From the second sentence, it was essentially a way for junket players to receive funds for gaming on credit.
Yes.
It was not just for junket players, it's also available to individual patrons playing on international individual programs.
I see. So should it read, it was essentially a way for junket players and players on an international program to
Yes.
receive funds. Okay.
That's correct.
Sorry, I think the evidence was for individual
Yes, sorry,
Yes.
individual.
playing on individual international programs.
Yes, sorry, that's correct.
Thank you. Perhaps while we are in your statement, could I take you to paragraph 34 of it, where you have set out a number of the systems, policies, and well, the documents that you've said contain systems, policies, and procedures when you occupied the position of AML and compliance officer. And could I ask that the operator could take us to CRW.702.002.2743. This is subject to an NPO. It's one of the documents you've referred to in the schedule to the back.
Yes,
I'm not going to take you to all of them. This is just one I would like to run through some of the parts of it
sure.
and understand what your role was at the time you were the AML and compliance officer. So you'll see from the first page, it's version 8 of the AML CTF program. And could I ask if you could scroll to section 3, which is on page pinpoint 2747. And in the third paragraph on that page is a reference to Executive General Manager Legal Services
Yes,
as the AML CTF compliance officer. That was Mr. Preston.
that's correct.
And then there's a position there, the first bullet point, AML and compliance officer. That was a position you held.
Yes,
And then the other positions, people may have changed in these, but General Manager Legal and Compliance, was that the right thing? That was Mr. Murray.
yes, that's correct.
And who occupied the position of General Manager Risk and Corporate Projects?
That was Miss Sasha Grist.
Okay. And at the time, General Manager Cage and Count?
That would have been Mr. David Brown.
It's Brown, okay. Now, you'll see that this passage, this part of the document identifies who will discharge the duties of the AML CTF compliance officer effectively in the absence of the designated officer, Mr. Preston. Was it your understanding that the people who fulfilled that function were in one of the people in those bullet points in that order?
I'm not sure if in that order. Certainly one of us would do that. And I would generally liaise with Mr. Murray or Miss Grist on those matters as well.
If Mr. Preston was absent?
Yes.
Okay. And in the period that you were the AML and compliance officer, was there any other person or people that fulfilled the functions of the AML and compliance officer?
Not that I recall.
So were the people effectively undertaking the function of AML compliance, you and Mr. Preston?
Yes.
Can I ask you if we could scroll forward a little further, please, to pinpoint 2749 and section 6. And there's a reference there to a risk awareness training program, and I could scroll a little further forward to the Appendix C, which is referred to in that part, which is at 2760. And was it part of your duties to carry out the training function for this program?
Initially, in the beginning, with the introduction of the AML CTF Act, we went out to different departments and did a presentation and provided probably more training to the cage that dealt with a majority of the transactions, and table games, who would do cash buy-ins at the tables. And then after that, it was predominantly an online training, although I would go to the cage and train any new cashiers and attend the dealer schools to do a little presentation at the dealer schools as well, the new dealers.
Okay, so you said we started.
Oh.
That. So who was providing the training?
Myself and Miss Sasha Grist would attend the initial one.
I see.
And after that, it was just me.
I see. So, so do I understand what you just said, that when the AML CTF Act came in 2007,
Yes.
there was a program of direct training of the various departments
That's correct.
that you undertook with Ms. Grist?
Yes.
See,
In the very initial ones
I
only.
see.
Yes.
And the online training, other than online training, was there any time at which you provided direct training to people in the cage or other areas?
Yes. So I would, whenever there was a new cashier, I would go and speak directly with that cashier and go through the AML CTF requirements. I would also attend all the new dealer schools. So I shouldn't say all new, every dealer school. So you would have dealers doing their initial training, and they might go back and learn another game. I would be at that second school as well, so just all the dealer schools. I also attended they're now called Table Games Managed, but the previous Pit Boss meetings, did some presentations there. The gaming machine management as well, we did training for them as well. The VIP room hosts and managers, we did training for those as well. And after the sort of initial training, it was more an ad hoc. So on top of the online, if any of the departments requested further training, I would attend.
I see. Was there a program that you developed yourself to provide refresher training, or was it, when you say ad hoc, was it at the request of the relevant department?
Yes, and I would tailor the discussion or the presentation to that department.
I see.
Focused on the types of activities they conducted.
All right. Could we scroll back in the document, please, to pinpoint 2751, which is a section on transaction monitoring. Well, we'll come back to this in a moment, but I just want to get an understanding of what your role was in this process. So you'll see there's a table there, and because this is a subject of an NPO, I'm not going to read everything out in great detail.
Sure.
There's a table there, and the reference to monitoring. Was it part of your function as the AML and compliance officer to be the person who was doing the monitoring?
Yes.
And in that column under the method, was that something that was part of your function?
Yes.
I see. And a little further down, there's a reference to reports of transactional activity being received and considered by, that's your position, the AML and compliance officer, with a view to cross-matching. Are you able to explain a little more about what that process involved in terms of the cross-matching data and looking for a rational basis to make those reports or entries in the register?
The last three items?
I'm looking at the section that starts reports of such transactions.
Oh, sorry, yes. Yes, so I would review the reports or any information that we received about patrons to decide whether we would need to do a suspicious matter, but also review any suspicious matters that came from any of the departments. So on the cash transactions report, that would also be reviewed by the cage, and they would do SMRs on those transactions that they felt, and I would review those when I received them, as well as reviewing the report.
I see. Was that an entirely manual task?
Yes.
So was it a matter where, if you like, the extent to which there were data was matching and, if you like, flags were raised or alarm bells were ringing, was a matter that was at least in part based on your experience as an AML and compliance officer?
Yes, and my experience in the cage.
In the cage, I see.
I previously worked in the cage.
So there would be an element of skill involved in that based on your aptitude for that task.
I would think so, yes.
And were the matters, when you independently decided, well, like, based on matching data, for instance, across different reports you'd received, did you have an independent role in then raising an SMR with Austrac, or was it something you needed to then run past Mr. Preston?
No, I had independent. I could raise them myself. I didn't refer them to Mr. Preston before I lodged them.
I see. And then, having lodged them, you reported to him at your regular meetings with him, did you, on the...
Yes, not necessarily every SMR. If it was depending on the circumstances of the SMR, or if there was multiple for one the same patron, we would look at that.
Is this, I think you referred to summary in your statement to maintaining a spreadsheet with SMRs and patron information on it?
Yes.
Is that
correct.
the kind of thing you're referring to?
Yes.
Okay, I want to come back to ask you some questions about that in a moment. Before I do, can we scroll forward to 2752, which is it's a heading risk rating, and there are several sections of the program that deal with risk ratings. 13 identifies low risk, moderate, significant, and high, and I understand that that's the gradual increasing of levels of risk.
That's correct.
And they trigger an obligate or a requirement to undertake additional know your customer steps in 14 and 15. I'm just setting this out. So there is a question coming. And then in 16, there's a reference there to high risk customers.
Yes.
What the Commission's interested to know is what kinds of conduct would lead to a risk rating of, say, for example, moderate?
Some ratings were raised to moderate if we had a patron where we didn't have a lot of information but may have done a number of transactions that we considered suspicious and had lodged SMRs on. So we might then consider that we'll raise the patron to moderate.
And what was the effect of raising a patron's risk rating to moderate in terms of what you did to monitor their activity?
Yep. So if they were raised to moderate, so any patron rated moderate and above, we would put an alert on through the psycho system, and then we would order reports every couple of days for the previous day's activities, and all their activities would come up on that report, and we would then review those activities.
And the decision to identify someone's risk rating as a patron's risk rating as moderate, was that your decision or someone else's?
That was made in conjunction with Mr. Preston.
So the two of you would discuss it
Yes.
at one of your meetings, I take it,
That's correct.
and then a rating would be assigned to the patron.
That's correct.
And what kind of conduct would result in a significant rating of significant?
There could be a matter of different things. It may have been some further information we obtained through the WellCheck system, which is we would run our patrons through. It was a database. So if we found out any information in there, if we had obtained any information via our security team and their contacts with the police, if there was anything further that they knew that we might not know, that might not be public knowledge. And then the level of number of transactions or the amounts of the transactions may also play into that as well, that assessment.
Okay. And what about high? How was someone rated as high risk?
Again, it would be dependent on any information that we had gathered from different sources, again, via the police, our contacts with the police, or WellCheck, or transactional activity, if we weren't able to get any further information on a patron via any of our sources, and we weren't sure, what was occurring, we would place them at high.
Okay. Now, as I understand, if we look at section 15, which is on page 2753, if a person is rated as at a high risk, it triggered a requirement, I should say, to do an enhanced due diligence, customer due diligence on them.
That's correct.
And that was the same as if a suspicious matter report was produced in respectively.
Yes.
And one of the things you're obviously interested in ascertaining are sources of wealth
That's correct.
and sources of the customer's funds. What steps were taken in the enhanced customer due diligence to ascertain that sort of information?
We would then contact the applicable gaming management, and a lot of the time it was to do with international patrons, so we would contact the international team and ask them to provide us with some information on those, their source of wealth or where their money came from, and they, in due course, would provide information that they had or contact some of Crown's overseas offices to see if they had any information as well.
All right. Now, in the time that you were the AML and compliance officer, were there occasions when a patron was considered to be such high risk that a notice of revoking licence was issued, or an NRL?
I'm not sure if there was one done specifically from an AML perspective. We did have some of our patrons that were on our risk register that may have been NRL'd by security or other departments requested.
Right. Now, my question really is directed to the it's really directed to section 16.
Okay.
I took it to you a little earlier, and circumstances where it was a customer based on the information you had about the money laundering risk was such that a decision was made to issue an NRL.
Not that I can recall, no.
And you were the AML and compliance officer from 2007 to 2013, and then had a stint in...
Late 2012.
Sorry, yes.
Yep. And then I did a stint in from October 2014 to March 2015 when Mr Theodoropoulos left Crown and they found a replacement.
Okay. Just before we leave this document, can I take you back then to section 7? And I'll come to this a little later, but I just want to. Section 7 deals with risk assessment, and there was Appendix E to the. You recall it has a risk matrix.
Yes.
And there's a reference there to risk assessment on designated services will be reviewed on an annual basis.
Yes.
Were you involved in any such reviews?
Yes.
And how were they conducted?
We would review the. I would review the table that we had of the designated services and the risks, and determine if there was any that maybe we hadn't covered that we may now know, or any additional ones that might have been added, and also look at any extra controls we might have put in place since the last time it was reviewed, and determine whether that would change the inherent risk rating.
And when was that undertaken? Is that one of these meetings with Mr. Preston, or was this at a legal and compliance meeting?
No, that was generally, I would do that and then speak with Mr. Preston about that on occasion. And then at a later date, we would also have a conference with Melbourne as well and their AML team, and compare the designated services to see if we had a difference in risk and whether either of us should adjust based on that.
And were there occasions when you were undertaking that task when you became aware of a new risk and it resulted in a change to the risk matrix?
Yes. Most of the if a new designated service was being provided, or there was a change to the rules of a game or the operational procedures, we actually had a form, it was called an AML CTF approval form, which the departments would complete around that new designated service, and then answer some questions, and then they'd send that to me and I'd review it, and then I'd take it to Mr. Preston, and Mr. Preston would review it and sign off.
What about risks in respect of an existing designated service that you hadn't foreseen but manifested themselves in operations?
Yes, well, if we became aware of it, we would take that in consideration and update the table if required.
Do you know if you were responsible for updating the table in 2014?
I don't recall, sorry.
All right, can I take you to another document? This is CRW.708.017.8439, also the subject of an NBO. And again, I think this is referred to in your table to your statement. I just want to draw to your attention, we touched on this a little earlier, this is on pinpoint 8442. There's a table there referring to training.
Yes.
And you'll see under frequency, there's a reference there for cage, table games, electronic game, international operations and surveillance to have at least annual briefings. And I think you said earlier in answer to my question that they were done on an ad hoc basis as requested or words to that effect.
Yes.
Did you have a program where you specifically went out annually to provide direct instruction in accordance with this table?
No, I didn't have a specific program, although I was in contact with the departments on a regular basis.
I see. Next thing I want to ask you about is procedures under section 3, which is 8443. if we have time, I want to take you to some of the legal and compliance meetings where some of these things are discussed, and I'd like to understand a little more about how this process of discipline worked in practice. So if a person was found to have breached an AML policy, as I understand this, they were given some counselling, at least in the first instance.
Yes,
And who provided that counselling to them?
it was usually the department management. If they requested me to attend with them, I would do that.
Okay, now if it happened again, the same employee, then what would happen?
Different departments do different, have different procedures. So some departments have what's called a documented discussion, where there's, I think they sit down, I'm not sure if HR is involved at that stage, and they go through the matter and ask questions and ascertain whether the employee doesn't understand the requirements, or whether they did, or whether it was just a mistake. The cage would have an incident report that they would issue, and it would be discussed with the employee, with the management team. They were probably the two predominant ones where the incidents came from, the breach.
And if it involved what is characterised as a major breach of an AML policy, how many warnings would someone get before it could lead to something more significant like termination of employment?
I'm not exactly sure. I know that we did issue written warnings on occasion to some staff, on depending on the breach and what occurred. So I'm not exactly sure what the HR policy is around the written warnings, how many you receive before you could be terminated.
Do you recall whether you were ever involved in a circumstance where an employee's employment was terminated as a consequence of an AML breach?
I don't think anybody was terminated. There was one employee who had a serious breach, but my understanding is that he resigned before it was a decision.
That was before he was pushed.
I think so, yes.
I see. Okay. I would like to take you to another one of the policies you referred to, which is the AML and Compliance Officer Standard Operating Procedures, which is CRW.708.019.3274. Again, this is subject to an NPO. Now, again, this is a document of some age. It's from the time when you were occupying the position, but I still understand that some of the information in it may be relevant to today's operations. So I will ask you questions in a way that tries not to be too revealing, but revealing enough for the Commission to understand what your evidence is. So there's, if I could ask you, draw your attention on the first page to the heading Daily, and there's a reference there to a psycho alert report. Is that the report you think you may have referred to earlier, where you have people who are on the watch list?
Yes, that's correct.
And so what kind of information does that generate?
So that report will list, it's fairly basically just list the patrons who have had any activity on the previous day, and it could be anything as simple as a change of address, or gaming activity, or the use of their member card at a bar or restaurant. So it lists everything. And then when I printed that report, I would then go in and look in the gaming system to see what gaming activity they had.
So if a patron, just by way of example, if a patron had front money allocated to their psycho or their DAB account, that would be referred to in the daily alert report.
So the report is not specific in what that activity is. It will just say either comment has been entered or there's gaming activity or something like that. So it's not too specific.
I see.
So it just gave us the opportunity to go in and reveal, have a look at that.
I see.
Patron.
So you would get the alert, and then if you chose to, you could then have a look at that particular patron's information, but you may not.
No, I would always check every patron on that list.
I see. By going into the system and then seeing
Yes.
what in more detail the activity was.
That's correct.
I see. And was it only patrons who were on the watch list for whom you got psycho alert?
Yes, that's correct.
All right. Then there's a reference there to iTrack.
Yes.
Is that what exactly is that?
That's our incident management system. So incidents in there can include surveillance, creating incidents to do with anything they've observed on the floor, whether it be dealers with breach of rules or procedure errors. There was a specific AML component to it. So the table games department, if they had a threshold transaction buy-in at the table, they would then create an incident in iTrack and attach a form that we would then use to make sure that that had been reported through our system, which then got extracted and reported to AUSTRAC. And also surveillance and table games would use it when they were completing an SMR. They would create an incident for that SMR as well.
And did you, as the AML and compliance officer, receive some sort of alert about what AML-related
Yes, that's correct.
items would be created in iTrack?
Yes, that's correct.
So, and this is something you also review daily?
Yes.
And I think I understand what a threshold transaction report is. And one of your tasks was to upload the reports to AUSTRAC?
That's correct.
And is there some sort of electronic interface
Yes.
with AUSTRAC, is there?
Yeah, we would extract the information from our psycho in a specific format and then go to the AUSTRAC website and upload it into the portal.
All right. There's a few other things on there. Roughly how long each day would it take you to go through the daily activities?
Oh, most of the day. Sometimes it would carry over to the next day.
Then under weekly, you've mentioned this, I think, in your statement about the Telegraphic transfer listing report, and that initially, at least, it was a weekly thing, but it may have become more frequent as there was more activity on that reporting system.
After my time, I believe that some of
Right.
they did it daily, but I never did it weekly for the preceding week's TTs.
Okay, so can you just explain what is the Telegraphic transfer listing report? What sort of information does that contain?
So on that report, there is it just lists the date of the TT, the patron's member number, their name, the amount, and that's about it. So it was a very brief description of what the TT was.
If you interrogate the psycho information, can you find out greater detail about that transaction, or is that it?
Sometimes, yes. We could zoom in on the actual entry in psycho and it may have more detail there. Sometimes there are comments added in psycho under the TT, but not always.
So is this a matter of how it was entered by the operator who put it into the system in the first place?
That's correct.
Okay, so just going back, you've mentioned two things. Sometimes there was more detail. What do you mean by that?
Sometimes when a TT, if it was to be early released, if they wanted, the patron had arrived but the funds hadn't cleared for the account, the cage who prepared them would contact management, senior management, usually the CFO and CEO, to obtain approval to early release those funds so the patron could play.
I see. And what about, I think you mentioned comments. Is it a comments field?
Yeah.
What sort of comments were put in?
It was generally around the early release, or if it was, if there was anything, any other information they might have that was relevant to that TT.
All right. And was there any suspicious matter reporting referred to in the psycho system, or was that purely an iTrack matter?
That was purely iTrack. The cage didn't use iTrack, so they would actually email the suspicious matters to me on a daily basis when they did them.
I see. So at this time, iTrack was not available to the cage?
still not available to the
I
cage.
see, and they need to physically make a report, do they, to the
Yes.
AML and compliance officer? What
That
about...
was at my time when I'm not 100% sure on the procedures now.
Understood. And what about the finance department? What did they have access to iTrack at the time? Were there occasions when you received suspicious matter reports from the finance department at all?
Not that I can recall.
And if they had wanted to, I presume they would also have required an email or
Yes,
direct contact with you.
that's correct.
Can I now draw your attention to the heading fortnightly, and there are 3 bullet points.
Mhm.
I think I understand the first 2. The third one it refers to risk triggers and risk register. What's that a reference to?
That's more the risk register, the spreadsheet I mentioned earlier, where I had put all the patrons where we had suspicious matter or information from WorldTrack. That was our risk register. That was the initial style that we used.
I see.
Yeah. And so any of the risk triggers, which could be in relation to an information obtained from WorldCheck or from the securities contacts with the police if we obtain any information.
And this is something you took to your meeting with Mr. Preston, is it?
Yes,
And went through the items of most interest each month.
that's correct.
Okay. Can we just move to monthly and a question about, it's on page 3277. It's quite a list of things for a person to do in a month. So there's something called a total buy-in report and multiple buy-in report.
Yes.
What sort of information was that?
So those reports were extracted from Psycho as well. In the very beginning, I used to review those reports, but we then moved it for the table games team to management to review those reports. So the total buy-in report was where there was a buy-in for 10,000 or more, and they would review to check that they had completed a threshold transaction report. And then the multiple buy-in report was when there was a patron had more than one buy-in over the course of that day, and they would review that to see whether they considered the buy-in pattern was suspicious or that sort of information.
I see. And is that only in relation to cash transactions in the casino, is it?
That one is only to do with cash buy-ins at the gaming tables.
At the gaming tables?
Yes.
Was there a similar report in relation to the cage?
There was only the cash transaction report, it's called, which is for all $10,000 transactions that occur at the cage, and also the ones done at the tables, when they keyed it in, it would feed into that report, so they would be on there as well.
I see. So the cage, both the cage and the tables were keeping track of cash received.
Yes.
And only cash.
For the purposes of
purposes.
reporting to AUSTRAC, yes.
Were you tracking other forms of transactions for your own data review? In other words, people transferring funds via electronic means. Were you keeping track of those sorts of patterns as part of your review as the AML compliance officer?
No. They were, just to clarify, they were transactions and they were always done as a TT release if they were transferred, patrons transferred money into the Crown bank account, which would then appear on the TT listing report. And in my review of that, although I didn't review because I didn't have the bank statements, and we were focusing on what they were doing with that money when they were at the casino. So whether they used those funds for play or whether they used it to redeem any cheque cashing facility or funds advance facility. So we would look then if those funds they sent in were being used for gaming purposes.
So that's really the point of my question. So if someone, say for example, transferred $100,000 into the casino account,
Yes.
didn't play,
Yes.
and then it transferred it out to a third party, for example, would that be the sort of information that would become available to you in some form?
Yes, because both the TT in and the TT out would be on that actual TT listing report. It recorded both. And so I would see that these funds have come in. I would look at their gaming activities, see they didn't have any, and then that the funds have been transferred out. And in those situations, we would do a suspicious matter. I
see. So does this fall in the category of one of the things I took to you a little earlier, which is the data matching function, where your eye and your judgment, if you like,
Yes.
as the officer, is being brought to bear on what looks suspicious?
Yes, that's correct.
Could we please now call up CRW.708.019.2771. We may have already touched on this. This is another document referred to in your statement. It's the Cage Austrac reporting standard operating procedures. And if I could just take you to pinpoint at 2772 and 2773, operator, we have those two pages side by side. You can see there, it gives some examples of matters that might be regarded as suspicious.
Yes.
In terms of the sorts of activities that take place in the cage.
That's great.
And one of the activities that's highlighted there is what is referred to as structuring,
Yes.
Which is breaking amounts up into transactions below the threshold reporting.
Sorry, what page are we on?
This should be in front
The
of.
pinpoint reference? No, unfortunately I don't have the screen.
It's on the bottom of 2772 and top of 2773. There's a series of.
Thank you. I've got those now.
In the course of the time that you were the AML and CTF officer, without asking about any specific transactions, when you were receiving the SMR information, to what extent were you receiving reports via email from the cage about transactions of this character?
Sorry, how often did you say?
Were you receiving SMRs from the cage relating to cash structuring, say for example,
Yep.
at all, or infrequently, or on what basis?
On the cage transactions, probably every now and then. It wasn't a frequent thing. I couldn't really say for certain.
Was it uncommon or common? Just as a general.
It's not uncommon, but it's not common. They would send me regularly on someone that might come to the cage and just reduce the amount under 10,000, not necessarily structure, do multiple. They might present 10 chips, and when requested for their ID, they would take chips back and say, I'll just do 8.
I see. And what about, I'll come to table games in a moment. All right. Now, in your statement in paragraph 50, I think we were there at one point, 50G, I think it is. You have made reference here to I think you've already referred to this today as well, the release, the telegraphic transfer release forms.
Yes.
And this is a document, so I just need to find the reference to it. It is CRW.529.001.9093. This will also be the subject of an NPO. And iPad's just having a little conniption. Sorry, I've had a little technical difficulty. Right, I've got it. Now this refers to an HSBC online banking account, although I think it was out of date at one point in time. I just would like to take you, if I could, through some of the procedures in this. And we start with on the first page under controls.
Sorry, what document are we looking at now?
So we should be looking at, if I not mentioned it, so it's 529.001.9093.
Thank you.
And a little down the page, there's about the, I think it's the fifth bullet point. It refers to access to our HSBC online banking is limited to approved officers only. And then the next bullet point is about TTs issued both inward and outward must be entered in the psycho system along with comments. That's, I think you were referring to that earlier.
There's actually two components to the comment section. There's actually comments within the actual TT screen, which is where they would put information about the early release. And then the comments that they're referring to here is basically when you first go into a patron number, a comment screen pops up and they would just record in that screen that a TT has been received and is available for the patron.
I see. Meaning available for the patron to
Use.
All right. Now on the following page, there's a reference there to some more. This is 0.9094. And there is a reference to not receiving funds from a company unless satisfactory checks have been completed. And then there's a reference there to there could be occasions when it's done, when it was done. In other words, you're receiving funds from a company. When we're referring to a company, obviously in some circumstances that may be and this is referred to a little later in this document, a bank or a non-bank financial institution, such as a money changer.
Yes.
So in what circumstances, if any, when, to your knowledge, were funds received from a company that was a third-party money changer?
Sorry.
Were there any circumstances, to your knowledge, when funds were received into a Crown account from a company
Yes.
known to be a money changer.
Yes, there was, I think, there was definitely funds accepted from money changers, such as the Raffles money changer in Singapore, or it would be listed usually on the actual receipt, or sometimes we receive notification from the bank itself to say funds have been received from that entity.
And so was that an exception to the general rule that you would receive funds from money changers who had been identified
Yes,
in the past?
yes.
And what of a new source of funds from a money changer?
I'm not quite sure what the cage would do in that situation.
Is it something that would be escalated to a senior manager for consideration?
Possibly. I would assume that cage general manager may be involved, and maybe with the finance team or then senior management.
All right. Can we scroll to 9.9095 as a heading operating procedures? And I just would like, if you could, just to assist with some of the terminology. And this is under the heading issuing deposits to our HSBC accounts. There's a reference there to an MT100. What's an MT100?
I think, I can't be certain, but I think that's in relation to the receipt from the bank, but that might be finance, would probably know what that is. I don't recall
All right.
seeing it myself.
Okay. There's reference to a psycho TA.
That is actually in reference to the TT release form. Each one is numbered and it starts with TA.
And so that is that the TA is a separate form, is it?
No, it's the same form on the requisition to release deposited funds at the cage, which we call the TT release form. There was a document number,
Right.
and all document numbers for those forms started with TA.
I see. But in terms of the psycho system, there wasn't a copy of the TT form itself in psycho.
So when the cage staff prepare the TT release form, they then enter it into the psycho system, which generates the TA number, which they then handwrite on the actual TT release form.
All right. Just so we're clear, when you as the AML and compliance officer are operating the psycho system,
Yes.
and you go into it to have a look, if you want to consider a TT, a particular TT, is there a screen you can open that shows you a copy of the handwritten form?
No.
There's a reference here also to a finance hexagon spreadsheet. Do you know what that is?
I believe it is the finance department kept a spreadsheet of all the accounts with the TTs if funds being assigned to a patron, but I'm not 100% sure.
I see. So is, to the best of your knowledge, the assignment of funds received into a bank account to a patron, I think you refer to it as a DAB account,
Yes.
was undertaken by the finance department, was it?
No, well, the funds were never actually removed from the our bank account.
Yes.
They were just notionally added to the deposit account. So it was
Like
just
a ledger.
Yes.
And so the control of that ledger was in the hands of the finance department, was it?
No, so the cage that was all within the psycho system, so it was controlled with the patrons as doing deposit and withdrawals. There was finance might on that on these Excel spreadsheets record that that deposit was assigned to that patron.
Okay, so that spreadsheet, which is referred to as the finance hexagon spreadsheet, was that accessible to the AML and compliance officer through the psycho system or by other means?
No.
So it was not available to anyone other than the cage, or
I believe so.
And there's a reference here also to income control. What does that mean?
Income Control Department are a part of the finance team.
And there's also a reference to a TA release file.
So yes, the TA paperwork or the TT release form was I think it was a 4-part. So a copy would be kept in the cage, a copy would be sent to finance, a copy would generally be sent to the Pearl Room, which is where the international patrons would obtain their funds, and then I think that another copy, the 4th copy, was retained in the cage, in the main cage.
All right, so can I just perhaps help you here? If we could scroll to page pinpoint 0.9100 and 0.9101 side by side. I think this is what you're just describing, which is the breakup of the paperwork.
Yes.
So the first one, which is the front page, the white front page, that goes to the Pearl Room.
Yes, that's
page.
correct. Yes.
A yellow copy. Sorry, we're on 0.9101.
Oh, 01.
A yellow copy goes to the finance TT officer. Is that, I assume that's the Telegraphic Transfers officer,
Yes.
on a daily basis via internal mail.
That's correct.
A blue copy is income control, who I think you said is also perhaps connected to the finance department.
Yes,
And the pink copy stays in the cage.
that's correct.
And as the AML and compliance officer, were any of those sources of the original information available to you?
They were not provided to me, no.
Well, there's a difference between
Yeah,
what they're provided and they're available.
I could go to one of those departments if I needed those documents.
So the one held in the cage is really the final copy.
Yes.
So, but in terms of all the documentation, which would include the deposit slips,
Yes.
there are 2 copies, one attached to the white original and one attached to the yellow. Is that right?
My understanding was that copies were attached to all of copies of the bank statement, and the receipts was attached to all copies.
And so, and they were to go to the cage, finance, income control, and filing.
Yes.
Thank you. And which copy would you access if you wanted to?
Normally I would contact the cage. Generally it would be the original, the white one that had the patron's signature for accepting the funds.
So do you know what all those parts of the business did with their copies, you know, once they were sort of, I suppose, you know, a month or so old or whatever?
I'm not. I know that the so the copy that went to income control, because basically when the transaction is processed, each float has to balance. So a copy of the TT is put in the float because it's been deposited to an account, and that's the part that would go to income control because they were in charge of checking that all the revenue has been entered correctly. So they would get that. I'm not sure what finance did with their copy when they got it. And the copies would be held and be archived after so long and held.
Thank you. Sorry, Mr. Future.
No, pleasure, Commissioner. Can I ask you now just to turn to your statement again, and I want to ask you some questions about paragraphs 63 through to 71, which is where you've dealt with you were asked to do some investigation for or provide some information to Mr. Preston in the early part of 2014, and I just want to make sure that we are working off the correct materials. So you haven't, I don't think, I'm not sure all these materials are in your attachment, your schedule, sorry. So if I could ask to call up CRW.701.005.5109. And alongside that, please, the next document in that sequence, which is 0.5110. And if we could just ask you, you referred in paragraph 65 of your statement to an email attaching an agenda. Is that the email and the agenda that you are referring to?
Yes.
All right. And there's a further reference, CRW.529.001.090, which is, I think you've referred to in 67. Sorry, got ahead of the operator. Is that the email you're referring to? Thank you. And the next document, I think we've... So, sorry, it's CRW.529.001.9091. You referred in that paragraph to a note. Is that the note you're referring to?
Yes.
And I think we've already been here. I think you refer also to the CAGE standard operating procedures for telegraphic transfers, and it's the next in sequence 0.9093.
Yes.
That's the document. Okay. Can we go back, please, if we may, to the email that you sent to Mr. Preston on the 26th of March, which is CRW.529.001.9090, and you've given evidence in your statement that you spoke with 3 people before you sent this email.
Yes.
Mr. Brown,
Yep.
Ms. Kessel, and is it Ms. Sao? Is it?
Xiao.
And I think you've said already earlier, Mr. Brown was the general manager of Cage and Count at the time. Ms. Kessel was involved in finance, and Mrs. Sao was also in the finance department. So do I understand from this email and your statement that you consulted with those people as part of gathering the information you used to prepare the note that was sent to Mr. Preston at this time?
Correct.
And the reference in this email to DB in the paragraph, first or second paragraph, it says DB feels that the ANZ concerns are regarding numerous deposit amounts under the threshold completed at multiple branches of the ANZ. That's a reference there to Mr. Brown. And where that sentence that starts, in most cases, and if not all, the patron presents the funds to the money changer or overseas staff in one amount, etc. Who was the source of that information?
Mr. Brown.
Now, I think as of March 2014, Mr. Theodoropoulos was the AML and compliance officer.
That's correct.
Do you know or have any understanding of why you were asked to be the one to provide the information to Mr. Preston?
I'm not certain, but on occasion Mr. Preston would ask me to get some information together for him, and the AML person was generally quite busy, so he may have asked me to do it to assist him.
Okay. Now, at this time, you had already had a considerable amount of experience in the AML and CTF area. The information that Mr. Brown had provided to you was quite clearly information concerning a possible structuring of transactions.
Possibly.
Yes. So he was clearly providing information that would have said to you as an AML and CTF officer that there had been transactions that were indicative of money laundering.
Yes, but I wasn't doing AML at that stage.
I understand
Yeah.
that, but it was clear to you that was the nature of the concern of the ANZ at the time.
Yeah, then Mr. Brown said he believed that's what the concerns were. Although at that stage I wasn't sure whether the account was a review or Crown, just the Burswood nominees account.
Now,
Say that again.
Oh, sorry. That I wasn't sure at that stage whether that was in reference to the Riverbank account or just the normal Burswood nominees accounts.
So at that point in 2014, you knew of the Riverbank account?
Yes.
now, you've the last sentence in there makes reference to having a discussion with some things that you wanted to discuss with Mr. Preston. Was one of the things you wanted to discuss with Mr. Preston a concern about the use of this account by money changers to break up transactions into smaller amounts?
I don't recall.
Can I take you now, please, to the note you prepared, which is CRW.529.001.9091. And this is essentially a response to the items on the agenda from the ANZ, isn't it?
That's correct.
And the source of this information is that do I make the assumption it's a mixture of your own knowledge and what you were provided by Mr. Brown, Ms. Kessel, Ms. Xiao, and by reading the standard operating procedures for the TTs?
That's correct. There's a heading account structure, and item 4 on that is a reference there to an overview of the management process, and there's a reference there in a bullet point to the finance department oversees the accounts management of or for whichever it is Crown Perth. What do you mean by that? Which point?
So we're on page 0.9091.
Yes.
There's 2 4s on the page. I'm sorry, it's the one about halfway down the page.
Yeah.
It starts overview of Crown account management, and there's a reference to the finance department oversees the accounts management of for Crown Perth. What does that mean? From
memory, that the finance department would review those accounts to ensure that. So if it was just our normal gaming account, if the deposits that the cage said have been done had matched the statements and things of that nature.
Is that you mean that reconciliation?
I think so, yes.
So to match up what's come into the account with what has been allocated to the DAB accounts?
I believe so.
Um,
Sorry, that would be not just funds to the DAB. This would be any gaming funds that were in or out, depending on what they were for.
Okay, thank you. Then there's a heading patron accounts. Am I right in thinking that's a general description for either the Riverbank Investments accounts or the Burswood nominees' accounts into which funds were deposited for gaming purposes.
Yes.
And so in response to the request for information from the ANZ about the channels employed to collect funds, you've identified there were 3 bullet points there.
Yes.
And you see there's a reference to either through the patrons depositing funds through their own bank or through a money changer in their country.
Yes.
So I'm correct in thinking that at this time, this note was prepared, one of the ways in which Crown Perth was receiving funds and was known to be receiving funds was via the use of money changers.
Yes.
When the next bullet point referred to is that patrons can also deliver funds to an overseas Crown office, what was your understanding of that process?
My understanding was that patrons could take their funds directly to, we had overseas offices in different countries, and then the overseas offices would then take that to a money changer or a bank and get the funds sent to Crown Perth.
So
Bank account.
a Crown overseas office would itself employ the services of a money changer on occasions. Is that
I believe so. I can't say for certain.
Sorry, Mr. Futrell, I just noticed this document's not on the public screens. Why is that?
This document, the note,
It now is.
oh, it's,
Now on the public screens. Thank you.
can I take you to the next item on this, which is item 2, it's cash deposit over the counter deposits.
Mm-hmm.
And am I right in thinking that the main source of this information was Mr. Brown?
That's correct.
And the reference there to over the counter deposit in the main tend to be money changers in Australia depositing the funds to the Crown Perth account that they'd received from overseas money changer to the patron has gone through. Do you understand the process by which money changers brought funds into Australia?
Not that I could say for certain.
So you were effectively there, are you reciting what you'd been told by someone else?
Yes, providing information, yeah.
Can I take you down to the next page, point 9092? And there's item 6, reference to the use of non-bank, non-ADI foreign exchange providers. The reference to ADI is a reference to the authorised deposit-taking institutions, isn't it? And they're authorised by APRA, by the Australian Prudential Regulatory Authority.
I'm not 100% certain.
Okay. But you understand
Yeah.
the ADI to mean someone who's authorised to
Yes.
receive funds?
Yes.
And there are 3 bullet points there. The first is that Crown Perth itself didn't engage in using non-bank or non-ADI entities. But then, we may have already touched on this, bullet point 2
Mm-hmm.
is that in here it said Crown's overseas offices. Is that a typographical error? Is it meant to be office, or are you referring to particular people?
Each office had a number of officers, so it could be anybody within that office. So an overseas officer.
And what were these offices? What are we talking about?
Their Crown's overseas, I'm not 100% sure what their full duties was. I think it was to arrange trips for individuals, apart from the junkets would do their own arranging. But if an individual player that was coming, they would assist them with the arrangements to come to Crown Perth.
And were these located predominantly in to our north in China and Macau?
I think later, yes. Before that was there was Malaysia, Singapore, Thailand, Indonesia.
I see. So there was an office that operated by people connected to Crown,
Yes,
and those individuals would sometimes use an overseas money changer to transmit funds for gaming in Perth.
As far as I recall.
And you've indicated there that patrons, it was understood that patrons did use non-bank and non-ADI foreign exchange providers.
That's correct.
Did it occur to you at this time, based on your experience as a AML and compliance officer, that knowingly receiving funds from non-ADI money changers was a high-risk activity from a money laundering perspective?
I don't think so, because at most of the ones that I had seen were well-known ones. As I said, like the raffles, which was a big one, which is, I believe, approved by Singapore's monetary authority. But I can't say that for all of them. I don't know.
All right, but needless to say, at this point in time, there was information available to you and other recipients of this email.
Yes.
That the ANZ had expressed a concern about the breaking up of transactions into smaller than threshold transactions.
Yes, that's what was David Brown believed that the concerns were.
And it was the case that those involved knew that some of the money changers involved in remitting funds to Crown Perth were not ADI approved.
I can't say what others knew.
Did you understand this time from your experience as an AML and compliance officer that one area of risk for money laundering was the use of money changers?
Possibly. I can't recall at the time what my thoughts were.
All right. Now, you were sent a meeting maker. You've made reference, I think, to this in your statement. Could I take you to CRW.709.132.7645? Now, I think you said in your statement that you don't recall being involved in the meeting.
Correct.
But you are listed on this document as required. Was it your usual practice to attend meetings when you were listed in as required for attendance?
Generally, yes.
And the organiser, Ms. Christina Smith, you knew that person to be the executive assistant for Mr. Barton?
No.
No? Who was she? Did you know who she was?
No.
Okay. All right. Now, I appreciate you've indicated that you don't have a clear recollection of this meeting, but can I ask you to?
Commissioners, this one has some personal information, including phone numbers. So
Oh, I'm sorry.
We won't show it on the restricted to the screen of the witnesses and the council solicitors and commissioners.
All right. I think perhaps we should just take that one down now. We don't need it anymore.
Right. Thank you.
All right. Now, you were aware, were you, around this time, that the ANZ Bank closed the Riverbank Investments account?
I can't remember.
You can't remember? Do you remember whether you became aware at this time of a direction that patrons were not to deposit amounts below $10,000 by cash into accounts of Crown Perth?
I don't believe I was aware that that direction had been issued.
All right, now, I want to show you a document. You aren't the recipient of this, but you may, I think you've given evidence to this effect in your statement. Towards the end of 2013, Mr. Theodoropoulos left Crown and you resumed the primary responsibility as the AML and compliance officer.
That's correct.
And then you recommenced your regular meetings with Mr. Preston for a time.
That's correct.
I'd like to show you a document, which is CRW.709.134.1143. And I just want to ask you some questions about whether you recall towards the end of 2014 becoming aware of an email from the Cage shift manager relating to a patron that had deposited $100,000 into an account through a series of transactions less than the threshold.
I was not aware.
You're not aware?
No.
Is it something that you would expect to have been made aware of as the AML and compliance officer?
I believe so. I think from the email it says there lower down that Mr. Preston requested the appropriate reports to be made, but I don't have any knowledge of receiving those.
Well, there's also a reference in to preparing an SMR. So I'm just wondering if you have any recollection, given the events of 2014 in the early part, of receiving an SMR relating to activities involving the breaking up of transactions into smaller amounts.
No.
Is it something that you think you would remember if it had come to your attention at the time?
Possibly, I can't say.
Is it a matter that you would expect to have discussed with Mr. Preston at one of your meetings?
Yes.
Okay, can I ask you if you could be taken to your statement again? So this is at paragraph 72 to 74, which is following on from what we've just been dealing with, where you've indicated that your next involvement really was when you were asked to undertake a review of the Riverbank account last year.
Yes.
And this document, I can't remember now what the status of it is, whether it's certainly non-publication. I don't know if it's anything else. I think you've referred to, I just want to get you again to confirm something for me. I've got a number of pieces of paper floating around, I'm afraid. This document, is it available?
Non-publication.
Non-publication, but is available. Is CRL.725.001.0153. And is that the email to which you're making reference in paragraph 74 of your statement?
That's correct.
Okay. Can I just ask you something about this? And I think we've dealt with some of these documents earlier. Down the page, there's a heading review methodology.
Yes.
And I think you're describing there what you had done to carry out your review. And then there's a heading a paragraph that begins original documentation.
Yes.
So you obtained the effectively the pink copy information that we referred to earlier from the cage, and cross-checked it against the bank statements
That's correct.
you had, and you found some letters from a money changer in amongst that material, and other supporting documentations that indicated that there was an acceptance of the amounts in full from the patron in question.
That's correct.
Then the next, you attached to that email some summaries of the work you had performed, and the first reference is CRL.725.001.0155. Now, I wonder, I'm going to ask you a question about this in a moment. It might be, can we be able to provide a paper copy, because it will be easier for the witness to look at it? No? Okay. I'll give you mine in a moment.
Sorry, what's the number?
So it's CRL.725.001.0155. And I understand, perhaps it might be worth just explaining the work you have performed here. I've made some assumptions by reading your statement and reading this document that you have gone to the bank accounts. You've really only looked for one sort of suspicious behaviour, which is small deposits on a given day.
Yes.
And you've identified the patrons, the amounts, and whether or not an SMR had been identified in the system.
That's correct.
And then some detail about the gaming for each one. And so that's one of them, I take it. The other, could I ask you to be shown CRL.725.001.0166, and again, this is for a non-publication matter. And I think it's a continuation of your work.
Yes.
And for a different period. Can I just ask you something, if we could scroll to page 0171. And perhaps if the operator is able to bring the bottom of that, so the top of the following page together with the bottom of that one, so you can read the full entry for the 21st of October 2014. I guess that will do. So on the screen you should see. That's better. Thank you. Now you'll notice the date and the amount corresponds with that email I took you to earlier. What I really want to ask you is where you have referred in that column to no SMR.
Yes.
Are you quite sure that wherever you've made that reference, there was no SMR in the system?
Not that I could find.
And where would you look to find it?
So the risk register, which I'd said initially was a spreadsheet,
Yes.
was moved to the Cura system, which we used as our risk register. And for each SMR, the patrons, we created a patron within the Cura system and listed whether they had lots of SMRs or World Chat matches or any other information. So I went to that Cura system, and the patron there was no SMR, and they were not listed in the Perth Cura system. So it would indicate that they had never done it, that no SMR had been received.
And can I ask you, do you understand the position to remain today that the cage staff are not able to directly make SMR themselves? They have to email someone before an SMR can be prepared?
So before the cage would prepare an SMR and lodge it, we'd review it, I would review it and add additional information or anything like that and then lodge it. My understanding is now that the cage prepare what's called an unusual activity report, which is then lodged with the AML team, and they perform an investigation and then they determine whether an SMR is required.
Okay. Now, I don't want to put you on the spot here. But you have in paragraph 79 of your statement, and you might know directly off the top of your head, and if you do, please let me know. In the last sentence there, you said in your review you found only one incident of aggregation where an SMR had been sent by the cage. I wasn't able to find that reference in the material provided to us. Now, it may be because it's buried beneath a secrecy blackout. But are you able to identify, if I provide you with the paperwork,
Yeah.
can you identify the entry where it was identified as an SMR?
I should be able to.
Okay. It might be if we could give the witness a brief moment, if you're prepared to, or we can.
How brief is a moment?
Well, I think maybe it depends. It would take no more than 5 minutes, I don't think.
Right. Well, we'll adjourn pro tem.
These are the two.
Please sit down, thank you.
Mate, please, the Commissioner was briefer than I thought. So perhaps having had an opportunity to look at those documents, were you able to identify it?
No, I wasn't. I do believe it was in the third column, but it may have been redacted.
All right, thank you. I would like to now ask you some questions about the process of the risk identification. We touched on a little bit earlier. And to do this, I want to take you to some minutes of the meeting, the AML CTF officer meetings with Mr. Preston. These are all the subject of an NPO, and they also, I think, have got some AUSTRAC material that means they can't be disclosed publicly. And parts of these documents make reference to either existing or past patrons and private information about them. I have heard the Commissioner indicate that we can't disclose that. So when I ask you questions, I will ask you questions of a general nature about them, and I'll ask you not to name any of the patrons when you respond. We were supposed to prepare a list of pseudonyms, but I haven't managed to do it for all of these, so we'll probably have to do it a bit on the run. So could I ask that the first document I'd like to take you to is CRW.708.017.4155. Now, you'll see these are minutes from July 2012, and if I could ask that we pinpoint point 4156. And there's a patron at the very end of the page where some information is identified having been sourced from a world check. And when one reads through that, you can see that there's information concerning associations with the mafia, commercial fraud, sale of counterfeit merchandise, and so on. And then at the top of the following page, there's a reference to the risk to remain low. Are you able to explain the process of reasoning that would lead to, with that information, a decision that the risk remain low?
From memory, with the world check database, there was very rarely was there a date of birth. And then also we would click on any of the links within that world check to see if we could find a photo to match it to our patron. So I think based on the fact that we couldn't identify that was our patron, being that patron's name only having 2, there was a lot of potential matches. So as we couldn't determine to any degree of certainty that was our patron, I believe that's why we remained at low.
See, was there any other checks available to you that would have allowed you to remove any uncertainty about the nature of that patron?
I would assume at the time, I can't remember, but we would have done a Google search as well to see if we could find any links or photos to that information to our patron. But yeah, apart from that, I don't recall anything else.
Did you have access to a more sophisticated means of identifying your patrons than the world check or a Google search?
No.
And then the next entry, again on page 4157, you see again there's is this the same category? There's a possible match. But in this case, the person had been approved as a junket operator. And what does it mean, risk to be determined? You're waiting on information, is it?
Yes, yeah.
Right. Could I ask when you move now to CRW.708.017.4301, these are minutes from November 2013. The patron in question I'd like to draw your attention to is about what's the second last patron name on the page, and this patron we will refer to as patron A. And there, you'll see in respect to patron A, there were 22 instances in the RR, which I take to mean the risk register, involving cashing out amounts without any associated recorded play. And again, so in that case, there is a decision to raise the risk to moderate. Are you able to explain why, in those circumstances, it would be moderate rather than significant or high?
No, I can't say why it was decided that. I can't recall what the...
I see. Are you able to form a view about whether that was an appropriate risk for a person who had been mentioned that many times in the risk register for that kind of behaviour?
Well, when we place them on the moderate, we would be monitoring his transactions more closely after that. So that may have been the reason that we just left him at moderate or just raised him only to moderate.
That's a relatively obvious indicia of money laundering activity, potentially?
Possibly, but also depending on what doesn't indicate there what sort of gaming he plays. But with our poker players, they don't actually have recorded gaming activity, so they might have a number of cash outs without any gaming activity because they play against each other, not against Crown.
I see.
So I'm not sure though what his
So it
game
may
is
depend on the nature of the games they're playing?
Yes.
All right. Now, if a patron is involved in a more general question, if a patron was noticed to be engaging in behaviour that was consistent with an indicia of money laundering, let's say, for example, loading up a FATG machine with lots of cash and then cashing it out without much play, were there any steps taken by the Crown Perth to prevent that person from continuing to play?
I don't know.
You don't know?
No.
If a person regularly appeared in the risk register for behaviours that were consistent with indications of money laundering, at what point were steps taken, if any, to prevent them from continuing to gamble at the casino?
Sorry.
If you had a patron, so it's just, this is a hypothetical, but who had been identified as consistently engaging in conduct that is consistent with one of the indicia of money laundering, at what point, if any, was a decision made to prevent that person from continuing to gamble?
That decision would have been made in conjunction with Mr. Preston. So it would be at one of these meetings if there was a number. When I was doing the AML, at each meeting I'd take along the patron's history from the risk register for him to review along with whatever the current information was. and at that stage, that was when those decisions were made or determined.
Was there any procedure of which you were aware as the AML and compliance officer whereby if a patron had been observed to be engaging in conduct consistent with money laundering, that person was removed from the casino floor or at that time?
I don't recall any.
You don't recall there was a procedure? Or?
Oh, sorry, I don't recall there was any patrons. Yes, it was. I don't know if there was a written procedure around the removal of a patron. Yeah, I can't recall if there was actual written procedure.
You were receiving. We just look at this page, for example, that we're on.
Mm-hmm.
There's a reference there to the number of TTRs for October. There's quite a few, and SMRs as well. So you were receiving SMRs on a monthly basis.
On a daily basis.
On a daily basis. What kinds of activities, I'm now referring to the table gaming area
Mm-hmm.
or electronic gaming machine area, were the subject of SMRs?
With table games, SMRs could be a patron buying in at the table and not playing, or buying in and only playing a little in comparison to the amount that they bought in, or if they split their buy-in, so bought in for $5,000 and then bought in for $5,000 a short time later. Sometimes when a patron might do buy-ins concurrently on two tables next to each other.
What controls were there from an AML perspective to where those observations were made?
So that was part of the training of the table game staff and the online training. So, and the inspectors and table games managers would monitor activities going on at the tables.
But monitoring the activity is one thing, but what did they do when they observed activity
So,
that was consistent with money laundering?
so I think it was the table games SOP talks about dealers or inspectors advising the pit boss, which is now called a table games manager, of those activities, and the table games manager would then complete the SMR report and create the iTrack incident and forward the SMR through.
Yes, there is. I've noticed in the risk register there's a reference in many cases to the control being the provision of an SMR. What I'm really asking you is, how is the SMR itself a control when the conduct continues and yet you've made a report to the AUSTRAC?
Well, we're making a report to AUSTRAC of something we suspect might be happening. We don't necessarily know if it's related to. It may be indicative, but we don't know. Some players have gambling behaviours. They do things for luck or just the way they like to play and things like that. So it's not necessarily always going to be indicative of money laundering. It may be just the patron's preference of buy-in or play.
Really, what I'm trying to get an appreciation of is what risk was being borne by the casino in continuing to allow people to gamble when you notice their activities were consistent with money laundering. So yes, it may be the case that they were not, because you would never know for certain, but at what point was if at all, was the fact that the conduct was consistent sufficient to say this is too high a risk for us to continue dealing with this patron?
I'm not sure.
Well, I think
With
earlier
the
you said
level.
you can't recall any instances when NRL was provided to someone for money laundering related activities. So is it the case that in your experience there was no observed behaviour in the casino that led to an NRL?
Not that I can recall, no.
Other than examples you've given of the nature of play, were there any SMRs you received in relation to other suspicious activities, such as the use of large or deposits of large sums of money in cash?
Yes, there were suspicious matters done on patrons that might come to the cage with a large amount of cash or even a lot of small denominations. I requested to change it to large denominations.
And were there, in your experience, were there repeat, I don't want to use the expression offenders, but patrons that repeatedly engaged in that kind of conduct?
Yeah, there were some patrons that did a number of large deposits in cash at the cage.
And what about those that you were involved in exchanging notes?
They weren't very common.
And were there any areas of the casino that were where the kinds of behaviours were more prevalent than others? So, for example, main gaming floor versus pearl room versus saloons, so salons.
The large cash deposits were more prevalent in the pearl room. But yeah, everything else was generally quite consistent, especially buy-ins at the tables. And
Go back to the legal compliance stuff that we're done here.
Commissioners, I have no further questions.
Thank you, Mr. Futrell. Are there any applications?
Please,
Penglis.
Commission, I have some questions. Ms Van der Clough, my name is Penglis and I represent Mr Preston. Can the operator please turn up document, it's an inauspicious start, document CRL 725.001.0153, and I understand it's a subject of an NPO. This is hopefully going to be Ms Van der Clough, your email of 22 September 2020 when Mr Futrell showed you a little while ago. Now, you give some evidence about this in your witness statement, but let's just summarise it. You prepared this document, as I understand it, at the request of Mr Murray.
that's correct.
You undertook the task that resulted in this document.
That's correct.
And that was while Mr Preston was giving evidence in the Bergen inquiry, correct?
Yes, that's my understanding.
And Mr Murray told you, as I understand it, that this issue of aggregation had become the subject of questions and answers by Mr Preston,
That's correct.
and that what Mr Murray wanted done was to start investigating the situation whilst Mr Preston was still giving evidence, correct?
That's correct.
And that resulted in your report of 22 September 2020, correct?
Yes.
Now, I'll come to that in a moment, but do you recall having a conversation with Mr Preston shortly after he gave evidence about this issue of aggregation?
No, I didn't.
No?
Sorry.
All right. Now, it's fair to say in summary that what you've done here is you've undertaken a detailed, I think you use the words manual audit.
That's correct.
So just to be clear, you've gone back to the source documents.
That's correct.
You've looked at what the cage effectively put into Psycho,
Yes.
but then you went back to the source documents, and as a result of that audit, your words, you were able to come up with the two tables, we won't call them up, but the two tables that Mr Futrell showed you being the attachments to this memo, correct? And then you prepared your email and you sent that to Mr Stokes.
I sent the initial email to Mr Murray, which was earlier in the year, and then I was asked later on to send the details to Mr Stokes.
All right. Now, this has to do with the cage, correct?
That's correct.
And you spent a long time in cage before becoming involved in AML.
Yes.
What was your reaction to what you discovered?
I was surprised.
tell the Commission why you were surprised?
I was surprised that no reports had been received from the cage in relation to those deposits. It's something I would have expected.
Were you surprised about the fact that Cage had aggregated sub 10,000 amounts and inserted them as an aggregated amount into Psycho?
Yes, I was. That was, I must admit, when I worked in the cage, I'd never seen any patterns of transactions like that in the HSBC account, and I would have expected at least either non-aggregation or for them to provide a suspicious matter with the details of those deposits.
And is it fair to say, putting aside whether or not one can criticise the system for being this way, but the system was such that AML reviewed Psycho, not the bank statements, correct?
That's correct.
And so AML's capacity to do their job in regard to Cage was dependent upon Cage accurately entering transactions into Psycho, correct?
That's correct.
And indeed, I think you've given evidence to this effect, but let's make it clear. One can't interrogate Psycho to access the bank statements, correct?
That's correct.
So a statement to the effect that had someone bothered to look at the Psycho entries, there were some entries that identified the numerous deposits below the reporting threshold on the one day in respect of the same patron. That's an incorrect statement, isn't it? In
Yes,
regard
I
to
would think so.
these
Yes.
transactions.
Yes.
Because if you looked at Psycho, you wouldn't have seen that
No.
information. You had to go back to the bank statements.
That's correct.
Or to the TTs.
Yeah, or to the TT documents.
Oh, quite. Now, related to that, I want to show you some evidence that Mr. Brown gave to the Bergen inquiry. I'm sorry I don't have a number for this, but I've called it before, so I know it's on the system. It's transcript of the hearing on the 4th of September 2020. And can we go, sorry. Thank you. And can we please turn, if the operator can turn to the page of the transcript 2118. You just scroll down. Oh. Is that up? Thank you. I don't know my ups and downs. I'm sorry, Commissioners. Mr. Evans wasn't much help either, I should say.
Rarely have been.
In any event, Ms. van der Klout, you'll see that that's where the questioning of Mr. Brown commences. Now, I'm just going to put to you some of the questions and answers and just ask for your comments. So, operator, can we please go to the page down the bottom, 2138? Thank you. Now, Ms. van der Klout, down the bottom you'll see Ms. Orr, so she was counsel assisting the Commission. No, so she wasn't. She was counsel for Crown. Said, Mr. Brown, you were asked a series of questions, you can read with me if you like, about the work done by Cage staff in Crown Perth in the period 2013 to 16 in relation to transactions on the Riverbank account. Do you recall those questions? Yes, I do. And over the page. And you said in answer to one of those questions that you believe the cage staff at Crown Perth were aware of their obligations in relation to anti-money laundering. Do you recall that? He said, yes, I do. Would you please explain for the inquiry what those obligations were? And then do you see his answer, the cage staff?
Mhm.
You just read that to yourself.
Is it possible for this to go on the public screen?
Yes. You would agree with that answer, I take it, Ms
Yes.
van der Klauw? All right. Can we go down just a little bit further on that page? Final paragraph. You'll see, yes, Mr Brown, to your understanding, how were your staff made aware of their obligations that you've just explained? Then over the page, Mr Brown answered, they were made aware through their ongoing training and ongoing annual training in regards to any sort of suspicious matters. You can read with me then. And did that online training, to your knowledge, deal with the concept of structuring? Yes. There is a component in there in regards to structuring of payment? Yes. Again, would you agree with that?
Yes.
Thank you. Can we then go back to page down the bottom, 2132. And down to just between at line 30. You see just about line 33, Ms Sharp. I just wanted to be a little bit more specific here. I should say Ms Sharp was counsel for the Commission. To the best of your knowledge, in the period 2013 to 2016, is it right that the people at the Crown Perth Cage who did look at these actual bank account statements for Riverbank were not looking at whether structuring or smurfing was taking place within those accounts? He says, no, I don't believe that to be the case, no. Do you disagree with that, Ms van der Klauw?
Yes, I disagree.
And indeed, if the people in Cage aren't looking for structuring, how on earth is it going to be the subject of a SMR? Do you have any idea?
No.
In other words, an SMR to come out of Cage requires the Cage people to be on the lookout for such conduct, correct?
Yes. I think, just to clarify, I think they understood structuring and that they would have did receive SMRs on structuring on cash outs, but I don't think they were looking at it from the deposits. So,
Right. They weren't looking at it from the deposit point of view.
yes.
So just to clarify then, you're saying you don't agree with the statement insofar as cash out, but you agree with the statement so far as cash in?
Yes.
But would you agree that if you ignore, I'll withdraw that, the notion of structuring is only going to be identified by people who are at the front line in regard to these accounts, correct?
Yes,
And that's Cage, correct?
that's correct.
And if they're not on the lookout for structuring, then it's going to get through, correct?
That's correct.
No further questions, please, Commission.
Thank you, Mr Plingus. Any other application? Commissioner Jenkins.
Yes, thank you. So in relation to suspicious matter reports, did you ever, when you were the AML-CTF officer, see that the EGM supervisors or the table games supervisors were filing SMRs?
Table games supervisors, yes, not, I don't recall any from the EGM supervisors.
And do you understand why not?
So with the gaming machines, they're our EGM machines have note acceptor limits, so you couldn't really bill stuff. Most of the machines are a $100 note acceptor limit, so you could put in $100, make one bet. You could then put in another $100, but you couldn't put any more money till you got back down under $100.
What about the fat
credits.
G's though?
The fat G's, yeah, they were part of the table games, fully automated table games. And my understanding is that the table games department, in conjunction with surveillance, were looking at any machines, if there was a machine that appeared to have a lot of money put in it and then there was not corresponding gaming activity.
So what about though, didn't the EGM supervisors supervise the fat G's as well, rather than table games?
Yes, I think they did move over to them at some stage, but I still think it was the table games team and surveillance that were looking at those that information. I'm not sure how they got that information, whether that was from one of the systems that Crown has.
Thank you for that. Now, in respect of the correspondence in March 2014,
Yes.
Why were you involved in reviewing the patron deposit processes when, as you say, you weren't the AML CTF officer at that time?
I can't say for certain, possibly because Josh knew of my experience in the cage, as well as AML, and that AML person being extremely busy, so he may have requested me to have a look at it.
You were at that point, however, a member of the AML CTF officer meeting group?
March 2014. I'm not sure if I was then. I attended a few meetings when Mr. Theodoropoulos started, and then when he left, and then I also attended in when the new person started in March of 2015 to assist.
You were in 2014 the compliance officer assisting with GWC correspondence?
That's correct.
Did it occur to you that this information about the ANZ having issues with the bank account should be reported to the regulator?
Not to me, no.
Then can I ask you, why were you asked in 2020 to do the Riverbank account review?
Because I work with Mr. Murray, and again, I think it was because I had the experience in the cage and also in AML, and again, AML being very busy, so he asked me to have a look at it.
And did he request that any similar analysis be done of the Burswood nominees' main gaming account?
Not specifically.
And do you know whether one's been done?
I do recall we did have a quick look at the statements, but we couldn't see any sort of pattern like we were seeing on the Riverbank account, AUD account.
Now, in March 2014, do I understand in answer to the questions from Mr. Futrell that essentially Mr. Brown what he told you indicated that structuring may be occurring in the Riverbank account, ANZ account?
Yes, he said that there was multiple transactions and he thought that was what the ANZ concerns were, so I would think that that's what it was about, this structuring, because there was multiple deposits for the same patron.
Did it therefore occur to you that, for the reasons that you've explained to Mr. Penglis, or were discussed with Mr. Penglis, that the AML CTF officer would not be seeing evidence of that, and therefore SMRs would not be being filed in relation to those transactions?
That's correct, yes.
So what did you do about that?
So in 2014, I gave the information to Mr. Preston, and I was understood that they were going to meet with the bank to find out exactly what the issue was, and I assumed that they would, the Cage and Mr Preston, along with the other Crown senior executives at that meeting, would make the decisions about what course of action to take.
And so you, in that email to Mr Preston, you said that David Brown had told you certain things, and did you discuss with him any further details about whether SMRs were, whether this conduct was being observed by the Cage and what the Cage was doing about it?
I don't recall the conversation.
Can I just clarify the first bit? David Brown told you that he thought that there was a breakdown to smaller amounts of deposits, because that's what you've recalled.
Yeah, that's
told you in the email.
Yes. So he thought that the concerns that the ANZ might have were about these multiple deposits into the account.
Right. And do you recall having any further discussion with him about that aspect of it, about who might be doing it, about why they might be doing it, how often it was being done?
No.
Then, in answer to the questions from Mr Penglis, you said that you think that the Cage would have been only looking at structuring from a cash-out perspective rather than a cash-in. Why would that be?
I'm not sure. I just, based on what occurred, it would appear that they were not looking at structuring through those accounts.
Was there anything in the AML CTF program of Crown's that back then, we're talking, say, pre-2019, that would have indicated to Cage staff that they should be looking at cash out and not cash in?
No, there wasn't anything in the program. Most of our AML CTF program was focused on the transactions that were conducted at Crown. So we would look at that deposit into the DAB account,
Yes.
rather than the deposits made into the bank account. Certainly.
Yeah. So, well, not certainly,
Yeah.
but I understand what you're saying.
Yeah.
So would you agree that at that point, even if no one in the Cage had specifically paid attention to the actual deposits, at the time there was a TT created for the cash out or for whatever other reason, that the AML CTF program that Crown had in existence at that time would direct that, would indicate that whoever was doing it should be looking at it to see whether there was a suspicious matter that needed to be reported?
We would look at suspicious matters in the context of them using those funds. There was nothing in the program about looking at what funds made up that TT release.
So you're saying that when an officer in the Cage is doing a telegraphic transfer for funds out and they have to collect the deposit slips, don't they, to attach to the TT?
There wasn't always deposit slips.
No, but if they
there
were
was,
to look
they
for
were
them,
there,
and if they were to find them, they were to attach them to the TT.
Correct.
And if they see that this person wants to take out $50,000, which has been deposited in 5 lots of 9,000 and something or other, or sorry, my maths probably doesn't add up, but you telling me that should not cause them to raise a suspicious matter report?
No. I'm sorry, I was thinking from the AML perspective once we saw the TT release on the report. But if the Cage, I would have thought that if the Cage saw multiple deposits into a bank account, at a minimum they would have prepared a SMR to send through to AML to review and lodge.
Sorry if I wasn't very clear on this in that respect. Thank you, Ms Vanderklau. I don't have any other questions.
Ms Van Kyle, I've got a couple of questions for you. I'm looking at your witness statement and it's paragraph 50, little h on page 12, and it's the last sentence in that paragraph. It's about third-party transfers.
Yes.
Now you say there that there was a change to allow third-party transfers. They were rare in your time. I take it that's your time in the cage.
That's correct.
Can you recall, or did you have a view as to the rationale as to why that change was made to allow third-party transfers?
No, I don't know that.
In your time as AML compliance officer after you left the cage,
Yes.
did you notice any increase in the prevalence of third-party transfers?
There was probably increase, but it still wasn't a large number of those transactions. They were still predominantly sent to the patron's account.
Are you aware that in the closing part of the Bergen inquiry period, that Crown commissioned a report from a company called Initialism about some transactions in the Riverbank account?
Yes.
And have you read that report?
Not incomplete.
Or are you aware that one of the indicia that Initialism took into account was the fact that it was a third-party transfer?
No, I understood that a review was done of funds deposited by a third party, but I wasn't aware that there was a review done of funds sent out to a third party.
With what you know now,
Yes.
do you regard the existence of the third-party transfer option as being a risk in terms of money laundering?
Yes.
And just one other question, if we could bring up, this is the TT release checklist, which Mr Futrell took you to. It's CRW.529.001.9100, and I think it's at 9101 that I'm interested in. It's the four copies that I'm interested in
Yes.
at the moment. The original, the white, that was forwarded to the Pearl Room cage. The second one, the yellow copy, forwarded to the finance TT officer. The blue copy, income control, and the pink copy was filed, I take it, filed in the cage.
Yes.
In the blue copy, income control, where is that situated?
That's situated within the finance department.
As is presumably the finance TT officer.
Yes.
And then now, in relation to the first three, the Pearl Room copy,
Yes.
the finance TT officer copy, and the income control copy,
Yes.
what did you have any appreciation of what those three officers or officers with an R, or officers just ES, would do with those copies?
My understanding is the cage one, they would, once it was completed, they would file it in the Pearl Room cage. I'm not exactly sure what the finance TT officer did in relation to the copy they received. And I believe the income control was around about, was to do with the float and the balancing, and so the cage does a balance every day, and so all documentation used to pay funds in and out is then bundled up and sent to income control, and they verify that there's documentation for all of the transactions on the main cage float.
Well, to the extent that the yellow copy and the blue copy were hard copy documents,
Yes,
and to the extent that they contained the source material, like deposit slips if they were available and could be found, and the bank statements, they would be attached to the blue copy and the yellow copy?
I believe definitely to the finance TT officer. I'm not sure about the income control one.
All right, thank you. Anything arising from that, Mr. Futrell? Mr. Davis, do you wish to re-examine?
Just one question,
Certainly.
which is actually arising from something, Commissioner, that you raised in relation to third-party transfers. So the Commissioner took you to paragraph 50H, where a change was made to allow third-party transfers. Are you aware that that's changed and that third-party transfers are no longer?
Yes, that has been changed. It is now not allowed. There's no third-party TTs allowed to be sent out.
Or in?
Or in, yes, sorry.
Thank you.
All right, thank you. Ms Vanderkar, thank you very much for your evidence. We'll leave the summons in place because there's another commissioner to review the materials and there may be other questions that need to be put to you. For the time being, you're free to go and resume your normal activities, and with our gratitude for your
Thank you.
efforts, thank you very much. And we'll adjourn until 10 a.m. tomorrow morning.
Thank you.